Not answering the lawsuit is obviously the worst choice because it can be deemed the waiver of any defenses and a default judgment could be entered. When a team doesn't show up to the game that they're supposed to be playing in, they forfeit their right to compete and they lose automatically. The motion to dismiss. The defendant may file a motion to dismiss the complaint when all the material facts taken in the best light of the plaintiff's view still do not provide sufficient legal ground for the relief of that the plaintiff is seeking. The facts or a dispute in the facts is not argued during the motion to dismiss. Normally, the argument revolves around case law or statutory law. Neither the actual plaintiff or the defendant will have to appear in court for the motion to dismiss, but the attorneys will appear for their clients to argue the respective positions at the motion hearing. The answer. Assuming the defendant is not successful on the motion to dismiss or does not file a motion to dismiss, the defendant will file an answer. The answer will either admit, deny, or state that they have insufficient knowledge with which to answer each and every allegation made in the complaint. Affirmative defenses. In their answer, the defendant will normally put forth affirmative defenses, which, if true, would negate the plaintiff's otherwise valid causes of action. For instance, in a breach of contract case, the defendant may put forth the affirmative defense of prior breach or fraud, claiming while the defendant did breach the contract, he did so because of the prior breach by the plaintiff or the fraudulent actions of the plaintiff. There are many affirmative defenses depending on the causes of action and the facts alleged in the complaint.